You can just go wild. We can move the hearing and torch down if you want.
Senate Committee on Criminal Justice will come to order. The clerk will call the roll.
Chair Flores,
Present.
Vice Chair Parker, Senator Hinojosa, Senator Hoffman, Senator Miles, Senator King, Senator Hagenbu.
Here. The quorum is not present. Good morning, everyone. This is a welcome back as we begin our going down our race to the end. That's 30-something days. Who's counting? I don't know, not me. But anyhow, welcome. Folks will be coming in and out, including myself. But we will conduct our business as efficiently as possible and thoroughly as possible to make sure that witnesses are heard. To make sure and register at the kiosk for those who wish to testify. Public testimony be limited to 2 minutes. So members, our agenda this morning includes more than a dozen bills designed to make Texas safer for all of its citizens, to ensure that justice in Lone Star State starts and ends with public safety. It's the intent of the chair to lay out the bills, and we'll leave them pending. As soon as we get quorum, then we'll vote them out today, hopefully. So, again, if you intend to provide verbal testimony or would like to take a registered position on one or more bills, register at one of the kiosks located behind the committee hearing room. So, anybody have any statement? You have a statement? I just made one, so you might as well, if you want to.
Let's go.
Let's go. So at this time, I'll hand over the gavel to Senator Hagenbu, as I have to go lay out a bill, but I'll be back as soon as I'm finished, and here you go.
Thing on? Yeah, maybe. All right, folks, this is my first time doing this, and I just found out, so I'll do my best. All right. The chair lays out SB 1666. The chair sends up the committee substitute SB 1666. Is there any objection to adopting the committee substitute for SB 1666? No objection. Hearing none, so ordered. I recognize Senator Zaffarini to explain the bill.
Thank you, Mr. Chairman. Mr. Chairman and members, Senate Bill 1666 relates to the payment of restitution by a person released on parole or to mandatory supervision. It is the companion to House Bill 3636 by Representative Will Metcalf. Generally, members, Senate Bill 1666 would require the Texas Department of Criminal Justice to include the victim's last name, address when transferring a restitution payment to the clerk of the court, while keeping confidential any information provided to the clerk regarding the restitution, whether TDCJ or a parole panel ordered the restitution, and transfer the unclaimed payments to the Crime Victims Compensation Fund after 3 years instead of 5. Generally, the committee substitute was requested by the department and the Office of the Attorney General, the Texas Comptroller's Office, and the County and District Clerks Association, and differs from the bill as filed, in that it would specify TDCJ must include the last address known to the victim, if it is known, when transferring the payment to a county, require TDCJ to publish on its website the contact information of a designated staff member who can respond to inquiries from county officials regarding transferred restitution payments, and eliminate the requirement for TDCJ to provide a record of prior restitution payments made to the victim. Thank you.
Thank you. Members, are there any questions of Senator Zaffarini? No? Okay. All right. Do you have any other witnesses, Senator, today?
If you'll open the floor for public testimony,
Right.
maybe someone will come forth.
Yep. Invited testimony for SB 1666 is now open. None? Okay. All right. Okay. Okay. So any invited testimony is closed. Now open for any public testimony. But go ahead and give us your name if you're for or against the bill.
Okay. Good morning. My name is John Warren. I'm the county clerk for Dallas County. I'm also the president of the County and District Clerks Association, and we are enthusiastically in support of this bill. I'm not quite sure. I know you have a busy schedule, but Senator Zaffirini laid this out perfectly. So I'll just entertain any questions that you may have. But this bill actually makes an efficient process for the Clerks Association to distribute that restitution. We've worked with, as Senator Zaffirini said, with all of the entities, the Attorney General, TD, CJ, Office of Court Administration, as well as the State Comptroller.
Very good. Any questions? No? All right, thank you very much. Appreciate
Thank you
it.
for your time.
Any more public testimony? None. Public testimony is closed. Okay, just say. We'll leave the bill pending.
Thank you, Mr. Chairman and members.
Who's up next? What's in there for me? Okay. The chair lays out SB 2776 and recognizes Senator Hinojosa to explain the bill.
Thank you, Chairman, members of the committee. Thank you for the opportunity to present Senate Bill 2776, which supports the expansion of the Credible Messengers program by allowing the Texas Juvenile Justice Department to disclose certain information with consent from formerly incarcerated youth. The Credible Messengers program is a promising initiative that invites these individuals who've successfully re-entered society to return to TJJD facilities and share their stories. These powerful peer interactions help currently incarcerated youth see a future beyond the justice system and encourage positive behavioral change. However, under current law, TJJD is prohibited from sharing any personally identifiable information, even when former youth offenders want to participate. That legal barrier is preventing the program from reaching its full potential. Senate Bill 2776 addresses this by allowing TJJD to disclose an individual's information only if that person is at least 18 years old, discharged from the department, and has given written voluntary consent. The bill ensures that no information will be released without that consent, and it can only be used for the specific purpose of the individual that the individual agrees to, maintaining privacy, dignity, and agency for those involved. This is a voluntary and controlled measure that gives individuals the opportunity to use their experience to inspire others, and it gives TJJD a much-needed tool to support youth who are currently navigating a very challenging environment. And with that, members, I respectfully ask for your support of Senate Bill 2776, and I'm happy to answer any questions you may have.
Members, are there any questions? No questions? Do we have any invited testimony? No invited testimony. All right. Invited testimony is closed. We have no scheduled for public testimony. Is there anyone who would like to testify on this bill? Seeing no public testimony is closed. We'll leave this bill pending.
Thank you, Chairman, members.
Thanks. The chair lays out SB 127 and recognizes Senator Hall to explain the bill.
Thank you, Mr. Chairman and members. This bill is simple. It seeks to hold professionals who work with children accountable for failure to report child abuse in a more sustainable way. As you all may know, failure to report child abuse is a Class A misdemeanor when the actor is professional, as defined by Family Code. Intentionally covering up child abuse under this section is a state jail felony. The statute limitations on these crimes is 2 to 3 years, respectively. However, we have seen multiple instances where serious cases of abuse are only discovered and made public years later, and the clock has run out to punish those who allowed it to go unchecked, and thus indirectly contributed to the harm done to these victims. This bill makes 2 changes. It extends the statute of limitations from 2 to 3 years and 3 to 4 years, respectively. It does not affect the actual level of crime for these actions. More importantly, these timelines are applied starting when the abuse is discovered rather than when it occurs. With that, Mr. Chairman, I have to take any questions.
Thank you. Any questions?
Thank you, Mr. Chairman. I guess, Senator Hall, in your presentation, you talk about an issue dealing with Rockwall Independent School District.
Yes.
Is there an issue with the statute of limitations, 2 years?
There has been, and we have had some information. There are others where the time just ran out, that it happened, that nobody reported it, and then when it finally became the light, it was too late to do anything about it.
And these are situations where it's intentional in nature, where let's say the staff person intentionally failed to disclose?
Without error having, because it went away and that didn't happen, I don't have evidence that says that it was intentional or unintentional. It appeared from what we were told that it was intentionally just overlooked.
So in those type of situations, just in general, under the 4-year statute limitations that you're proposing, you would have to show that it was there was intent, and not only not disclosing the child abuse situation.
That's correct.
Okay. Thank you, Mr. Chairman.
Do you have any invited witnesses?
I don't believe, we don't, no, we don't.
Okay. Invited testimony is closed. Public testimony is open. Do we have any public testimony? Mr. Cody Taylor, public testimony. Please introduce yourself and for or against the bill, and you have 2 minutes.
Yes, sir. Cody Taylor. I am for the bill. I think it's a great one. And I'm going to state on the backside of this and the child custody issues. When you walk into family court, it never is file a petition, go to court, and you're done within a year. It usually drags on for 2, 3. Sometimes we've seen the complete bizarre things of 10 years. Well, what happens is in the course of that, all of a sudden, this statute of limitations takes place. Now, all of a sudden, there's child abuse allegations or false allegations. And then the issue is either the statute of limitations has ran out, and the case is still pending, but there's nothing to do investigative-wise, or the simple fact of is that there's false allegations, and now you have to go through the civil or possible criminal side to this. This gives it, when it's found as a part of where it's actually happened, that gives the actual victim or alleged victim a chance to actually make it right and whole. So I think it's a great bill, what Senator is doing here. It's tremendous. I think this is a bill that needs to be standing alone. It should have been done years ago, but this is where we sit now. So I hope you take this into consideration.
Very good. Appreciate it.
Thank you. Great bill.
Is there anyone else who wants to testify on this bill? Seeing none, public testimony is closed. We'll leave this pending. Thank you, Senator Hall. Good seeing you. He's going to be next. Got another one? Okay. Got another one? Okay. The chair lays out SB 1980 and recognizes Senator Hall to explain the bill.
Okay. Thank you, Mr. Chairman and members. Across Texas, peace officers, parole officers, and emergency personnel put themselves at risk daily while performing critical public safety duties. However, current law does not impose sufficiently strong penalties on individuals who assault or interfere with these public service, leading to a rising incidence of violence and disruption in their work. Without stronger legal deterrence, offenders face relatively minor consequences, leaving first responders, law enforcement, and other officials vulnerable to attacks and obstruction while on duty. Texas has a duty and a responsibility to strengthen protections for public servants by raising penalties for assault and broadening the definition of interference, helping ensure safe working conditions for those who enforce Texas law and provide emergency services. Therefore, this bill would increase the criminal penalty for assaulting a peace officer, parole officer, or community supervision officer while they are performing officials' duties. Presume that the offender knew that the victim was a public servant if they were wearing a distinctive uniform or badge. Expands the definition of interference with public duties to include disrupting parole officers and community supervision officers, and establishes a rebuttal resumption that intentionally publishing the personal information of law enforcement officers or their family constitutes interference with their official duties. With that, Mr. Chairman, I have to take any questions.
Okay. Members, any questions, Senator Hall? No questions? Do you have any invited witnesses for this?
Yes, we do.
Okay. And invited witnesses are invited witnesses is open. Please identify yourself and if you're for or against the bill in 2 minutes.
Yes, sir. Mr. Chairman, committee members, my name is Chad Fogg. I am with the Rockwall County Constable's Office. I am voting in favor of this bill, and I would appreciate your positive vote in this matter. And if you have any questions, I'm here for anything that you may have.
Okay. Any questions? All right, thank you.
Thank you, sir.
Any more invited testimony? Seeing none, invited testimony is closed. Public testimony is open. Do we have any public testimony of Mr. Michael Bullock?
Thank you, Mr. Chairman. My name is Michael Bullock. I'm the president for the Austin Police Association, been an officer with the Austin Police Department for about 8 years now. As president, we represent over 1,400, almost the entirety of the Austin Police Department, including the line officers that are impacted greatly by this type of offense. And one of the biggest things I'll just point out briefly is that this offense, because it is such a low-level offense, goes underreported, where oftentimes, especially in major cities, it is not even worth it for an officer who's impacted by this to even charge someone with it, because very little punishment is ever imposed if the offense is ever even prosecuted. So it has a distinct impact on morale here in Austin, also for our officers that work in our entertainment district, where there is a high frequency of assault on officers' threats. And so this has this type of legislation will be very beneficial to officers being able to safely do their job and to ensure that people are respecting the work that they are doing when they're operating in an extremely difficult environment. So we would ask that the committee support this bill and thank Senator Hall for his work on it.
Very good. Any questions? No questions? Okay, thank you.
Thanks.
Do we have anyone else here who would like to testify on this bill? Seeing none, public testimony is closed. Thank you, Senator Hall.
Thank you, Mr. Chairman, members.
As a matter of pending business, Chair lays out SB 476. Chair lays out SB 476 recognizes Senator Middleton to explain the bill. Is it pending? So, wrong bill.
Sorry, that's incorrect. It's,
Show me which one it is. Then. Sorry.
it is, that's just wrong.
Is this the wrong number? I apologize. Okay.
One number off.
We need like 2 or 3 more people to help me out here. Yeah. Sorry. In correction, the chair lays out SB 456 and recognizes Senator Middleton to explain the bill.
Thank you, Mr. Chairman, members. SB 456 deals with illegal organ purchasing and trafficking. This is a bill that we passed out of this committee last session, passed in the Senate as well on the local calendar. Did not make it through the House. Senate Bill 456 deals with the scourge of organ trafficking, which makes up actually 10% of organ transplants around the world. And there is a dark underworld and industry that is profiting off human organ sale. It is estimated that between $840 million and $1.7 billion is earned annually through organ trafficking. And as we know, our state is a proud leader in law enforcement and stopping organized crime, human trafficking, drug trafficking. But we have left this evil practice of organ trafficking with inadequate penalties. Individuals have reported being misled, coerced, or otherwise forced into selling their organs. And we know stronger penalties for this action have effectively deterred this crime in other states. Currently, the offense of purchasing or selling human organs is classified as a Class A misdemeanor, which is obviously very low. That includes criminal trespass and perjury are examples of Class A misdemeanors. And this obviously pales in comparison to the magnitude of this crime. Senate Bill 456 revokes a physician's license for knowingly using these organs in violation of the penal code. And as well, it increases the criminal penalty for purchase or selling human organs from a Class A misdemeanor to a state jail felony.
Okay. Members, any questions, Senator Middleton? No questions? Okay. Do you have anybody with testimony?
I do.
Okay. Anybody testimony is open? this? Do we have invited testimony?
I believe so. I'm sure.
Okay. Can we do public testimony and switch it around? Let's do public testimony first, and we'll come back to invited if they're here. Is there any public testimony? Anyone who wants to testify on this bill this morning? No public testimony? All right, public testimony is closed. Well, we'll leave it pending. If the witness wants to come back, if we need him, we can do it at that point in time. All right, thank you. All right. So leave the bill pending. Leave this bill pending. What's the next one? 611. All right. Okay. The chair lays out SB 2611 and recognizes Senator West to explain the bill.
Thank you very much, Mr. Chairman and Senator Hinojosa. Last year, Graceland, the historic home of singer Elvis Presley, became the subject of national attention when some attempted to use deed fraud to literally steal the property, Mr. Chairman. Graceland is just one example of an attempt to steal a property through deed fraud. In Texas, real property theft and fraud has increased exponentially over the last few years. This has caused more innocent landowners to have to fight to maintain their property rights. This bill is a nuts and bolts effort to insulate property owners from bad actors and strengthen investigations and prosecutions of real property theft while providing actual remedies for victims of these crimes. Before I get into the specifics of the bill, I want to talk about one of my constituents who has experienced real property theft. Being handed out, I think it's already handed out to you now, and there's a written statement from Norma Adam Wade, a resident of Senate District 23 who has experienced and is still dealing with real property theft. Here's what Mrs. Wade had to say about the theft that took place concerning her lot in Dallas. The signature, supposedly mine, clearly was forged and looked nothing like my actual signature. The document looked very unprofessional, with some lines crossed out and the location changed in handwriting from the state of Florida to Texas, and the county name had been written in by hand. Ms. Wade found out her property had been stolen because her tenant woke up one morning because trees were being cut down on her vacant lot next door. In her case, the theft was so bold that the property, Mr. Chairman and members, was actually listed by a real estate broker on the multiple listing service. Let that sink in. That's how bold it was. Yeah. Now, let's talk about what this bill does. First, the bill creates specific crimes in reporting for fraud related to real property. At present, theft of real property is treated no different than theft of a purse. Under this bill, some language from the theft and fraud statutes have been moved to a specific new criminal codes for real property theft and real property fraud. This reinforces that these are crimes against real property owners, buyers, bank lending on real property, and title companies insuring title. That's what this is about. Currently, a real property thief, thief, even after conviction, is still the apparent owner in real property records. Think about that. Is still the apparent owner in real property records in this state. Let that sink in. This bill facilitates ways to help victims return title to their names in civil court that they do not currently have. Critical tools are included in this bill for real property owners to have this issue addressed by a civil court to an effort to clear their title. This bill provides for restitution to the victim, lending agency, and the title companies who have paid out the fraudulent claims providing for extraordinary solutions for these extraordinary crimes against property owners in Texas. Members, in short, this bill does the following. It creates a 10-year statute of limitation period for real property theft and real property fraud. It requires that the judgment identifies the real property that is subject of the theft, and requires that the judgment be filed in the real property records of the county. It requires a trial court to order restitution for the value of the benefit, the value paid by title insurance, the value of actual loss, cost of repairing any damage to property, or attorney's fees related to the action to quiet title. Restitution is not required or may be reduced for the value of interest if the defendant executes a quitclaim deed to remove the cloud of title. It clarifies that a judge may clear a title without notice when a document or instrument purports to create a lien or claim on real or personal property, and the document reflects the real or personal property is subject to a criminal judgment. It moves the offense of theft of real property from the theft statute into its own new section, Section 31.22, allowing for the tracking of this offense in the state of Texas. This section also adds enhancements for targeting the elderly and also homestead. It moves the offense of real property fraud from the statute into its own Section 32.56. This section also adds enhancements for targeting the elderly and also homestead. Members, Mr. Chairman, the fact is I do have a committee substitute that is not ready yet. It makes some minor changes and does some cleanup, and we expect we'll have that ready for you to have it voted out by tomorrow morning if you have a meeting.
Very good. Members, any questions of Senator West? Okay. Do you have any invited testimony?
Oh, yes. Yes, I do.
All right. Invited testimony is now open. Call Audrey Hogg, Michael Willis, Paul Dodson, and Carla Rankin. Please state your name, your position on the bill, and you have 2 minutes. We'll start at this end and just go down this way.
Mr. Chairman, let me also say this. What we've done also is taken us from a Class A misdemeanor to a state jail felony and fraudulent filing with intent to defraud from a state jail felony to a third-degree felony also.
Good. All right. Good. All right. Go ahead.
Good morning. Chairman and committee members, thank you for allowing me the opportunity to speak today. My name is Michael Willis. Is that better? My name is Michael Willis. I'm here to support this bill and to share my personal impact of a crime that not only affected me financially, but also shook my faith in the very system that are supposed to protect property owners, particularly the actions of a licensed realtor who committed property fraud against me. I counted on the integrity of a licensed professional buyer's agent, believing that their position and license meant that they were held to a higher ethical standard. Unfortunately, that trust was violated. What I discovered was that my property had been fraudulently manipulated and left me with significant emotional and financial harm. The crime cost me more than just money. It disrupted my life, caused emotional stress, forced me to second-guess real estate agents, and I found myself distrusting not only individual professionals, but also the very system of property records and safeguards that are supposed to prevent these kind of violations. I now live with the constant worry that it could happen to me. With a licensed professional involved, it could happen to anyone. I urge those in position of oversight and authority to recognize how damaging property fraud is to victims. Justice in this case isn't only about holding the perpetrator accountable. It's also about restoring the integrity of the system we depend on and ensuring this doesn't happen to another person. Thank you, and with that, I'm available to answer any questions.
We'll go through the whole panel and open up for questions, but I can't imagine how difficult that was. Thank you for come in to testify about it.
Thank you.
Yes, sir.
Good morning, Chairman Parker. Good morning, committee members. My name is Paul Dodson. My grandmother was a victim of deed fraud. She had her home stolen from her several years after she was actually deceased. So this fell on my mother's shoulders, who was also an elderly. Found out through a realtor that the home had been taken out of the family name. Can't tell you how unimaginably hard it was to break that news to my mother and let her know that the home she grew up in and the home that she was told would be hers one day was no longer in the family. It was very disheartening. It was a very humbling experience to sit down and say, I absolutely do not know what to do here. I'm a businessman. I've handled many accounts for many years, and to be able to look at my mother and say, I don't know if this is a legal matter, a civil matter. I don't know who to turn to, where to turn to, or what to do in this situation. And that really ate me up. It caused me a lot of turmoil. It's caused turmoil still to this day, as the home is still not back in the family name. And I'm here to support Senate Bill 2611 and anything we can do to help its passage. I appreciate everyone's time here and open to any questions or anything that I could assist with going forward.
Good. All right, thank you. Just a quick moment here. Let the record show that Senator Hinojosa and Senator Huffman as present. Okay, we'll go ahead, please. Please give your name and your position on the bill.
Good morning, Mr. Chairman and committee. Thank you for this opportunity. My name is Audrey Hogg, and I am for this bill. I'm here to speak about my uncle. Colonel Liddell Young was my uncle and my surrogate father. He was a military veteran, dedicated and decorated educator and real estate investor. Mr. Young served 4 years in the U.S. Army and received an honorable discharge. He then enrolled and graduated from Texas State University and later North Texas University with his master's. After college, Mr. Young went on to become a fifth grade language arts teacher at Lakewood Elementary School. He was not only a teacher, but a dedicated support system for many of his students. He received Teacher of the Year in 1991. After 34 years of teaching, Mr. Young closed his lesson plans for the last time and retired from the Dallas Independent School District. Upon retirement into supplementary income, Mr. Young decided to start his journey into real estate investment to secure his family's finances upon his death. Mr. Young purchased properties and had the talent and knowledge to rehab them himself. These properties were then leased to individuals he knew were in need of affordable housing. Mr. Young's health started to decline in 2020, and he took the time to ensure that his estate and affairs were in order. He also ensured that his final wishes were well documented. When he passed away in February 2021, it was discovered that a former student who had recently been released from prison and required accommodation had a deed indicating that the property had been transferred to him. This set the entire estate on its head. An investigation revealed that forged deeds had been transferred to the ownership of 8 properties worth over $1 million in Dallas County. Per the tenant, Darrell Freeman, he along with his caregiver, Anthony Tucker, and wife Belinda, conspired to take the properties as Mr. Young was the perfect individual, 84 years old, senior citizen, no wife or children. The property that Darrell Freeman, the tenant, is living in was deeded over to himself. The other 7 properties were deeded to Anthony and Belinda Tucker and their Inspired nonprofit organization. The fraudulent deeds were backdated to July 2020, but not recorded until March 21 after the death of Mr. Young, during which time Darrell Freeman, the tenant, was still paying his monthly rent. As of today, this legal battle has cost the estate more than $150,000, and we are still fighting this battle along, grieving the loss of my uncle. Thank you.
Thank you. State your name and position on the bill in 2 minutes.
Thank you. My name is Carla Rankin. I'm an attorney in Rockwall. I do family law, and thank you for having me here. In July of 2018, I was retained on a case that involved past due child support and modification on a custody case. The opposing party owed a significant amount of money in back child support. I was very diligent in my research, trying to find income as the party wouldn't turn over discovery. In that research, I located a house for sale listed for sale by the opposing party in Houston. I started digging around and looked up deeds with my background in real estate and found deeds back to 2014 that had his name on them, and he had fake affidavits of heirship for people that did not exist, conveying properties to children of these parties who had been deceased for 10, 20, 30 years. And they were also notarized by this opposing party long after these people had been dead. When I, as a continuing crime, because I saw where they were recent within the last week to 2 weeks, I reached out to local law enforcement. I was told it's a civil matter. I was told you're not a victim. I had my client go and do affidavits with the police departments, and I was told, we'll get back to you. That was in 2018. Some of the deeds went back. The ones I found were older than 2014, which the statute of limitations by the time I discovered it would have almost ran. Then you have an investigation and the time that takes. I found alone over 24 homes in Dallas County that were, I believe, fraudulently conveyed by this one individual. I met with the FBI. I met with federal officials. I met with local and state and was turned down over and over and over until 2020. The money that the person, just this one individual, received that can be proven is well over $1 million, and a lot of the homes have still not been returned to the rightful owners' families. And the people who do this, they don't pay real estate tax. They don't pay tax on the income. And they prey on the elderly, the low income, and minorities mainly in this. And I support the bill and thank Senator West for proposing this bill. Thank you.
Thank you all for taking time to share these difficult examples with us today. Members, are there any questions of the witnesses? No questions? Okay, thank you. Thank you very much to each of you. Looks like we have one more invited witness, Robert Brown. Please state your name and your position, and we'll give you 2 minutes.
My name is Robert Brown. I am the chairman of the board of the First Christian Church of Lancaster, Texas, which was the victim of deed fraud theft. And I am testifying in support of Senate Bill 2611. A nightmare of confusion. We found in early May 2019 through the Dallas Appraisal District, they sent us letters wanting to know the sale price of our 2 parcels of church property. We hadn't sold any property. I immediately went to the appraisal district. They showed me the paperwork, went to the county clerk's office, got the quitclaim deed copies that had been supposedly supplied to the county clerk, and they were fraudulent in every respect. There were people on there that had no connection with our church, were not known to any members of our church, and yet they had been allowed to be accepted. There was no corroborating evidence that these people truly represented the First Christian Church of Lancaster, Texas in any way. This began a 2-year frustrating effort to get our name back on our property and get things back made whole again. It took 2 pro bono attorneys working for us. It took Government Code 51.903, that's what was used to get the fraudulent documents removed and get the church back in our name. It took another 3 years to last May to get the perpetrator convicted. It was an absolute nightmare for myself, for my minister, for my financial secretary, our entire church. Just a nightmare that this could be allowed to happen. that a person could go in to the county clerk's office and give them a quitclaim deed and not have to show any kind of identification that they are who they say they are. That's wrong. Just wrong. I thank you for the favorable consideration of this bill, and I am happy to answer any questions you may have. Thank you.
Thank you, Mr. Brown. Yes, you have a question?
Yes, sir, I have a
Please,
question.
we have a question for you.
Sorry, I have a question for you. Sorry. Which county did you say?
Dallas County.
Dallas County.
Yes.
Secondly, what sentence did the person, you said they were convicted?
He got 35 years.
35 years.
Prosecution asked for 50. He got 35. We were happy with that.
Did he have a prior history or was...
It was revealed in trial that this perpetrator had like over 7, 8, 9, 10. He tried to steal other properties.
Okay.
Our first attorney that I dealt with had already had prior action with this individual because he tried to steal a church before he stole ours.
Okay, so it wasn't an isolated incident. Secondly, was he working with other people? Was it sort of an organized situation? I'm trying to
He had
figure out.
This is what bothers me. He had people on that document that, yes, he knew. They didn't get prosecuted. We as a congregation felt that they should have been included in the prosecution too.
Okay.
But he was the only one that got prosecuted.
But he did get 35 years.
He
so
got
that was very
35
good.
years.
Good
He's
for
down
you.
there now.
Thank you for sharing your story.
Thank you.
Can I ask Senator West a question?
Certainly, yes. Go right ahead.
Senator West, I'm curious, as you prepare this bill, and I know we don't have the committee sub yet. I'm interested in looking at it, but did is this like an organized crime effort, or is it more isolated incidents where people, just take advantage of the vulnerable, the elderly, or maybe the uninformed, or something?
Very good question. I think it's a combination of both.
Okay.
Okay. And I have a county clerk here, John Warren, that can also talk to this. I mean, the reality is trying to clear the title, and you understand that.
Yes.
And so what we do with this particular legislation, assuming favorable consideration by the legislature, we put in place a mechanism where the title can be cleared once we have a criminal conviction by the court. That's the novel, I guess.
Providing a civil remedy that just hasn't been there before.
That's not there. And if you want to talk to Mr. Warren right there, he's here also. He can kind of give you some additional background on this, but it's a combination of both.
Committee sub, which I'm sure will answer some of the questions. And I walked in a little late. I apologize, but I find it's we've addressed some issues now that the chair's not here now, but in here about how the elderly are taking advantage of this session, and we've had in this committee, and we've heard several instances, and this seems like another situation where the elderly are particularly vulnerable.
That's exactly right.
Just impossible to try to right the wrong, to try to get through the process, and not necessarily the fault of the local officials, but just there's not something in place to help them. So,
well, to his credit, he brought this to me and said we needed to do something.
I just hope what you do is not, I haven't seen it again, it's not too complicated. We need to make it as streamlined and as easy as possible for the victims to
be able to utilize it.
To utilize it. So that's how I would look at it.
And I like your eye on this.
Yeah.
The other committee members' eyes on it. I think you understand why we need to do this.
Absolutely.
But we need to make certain that it is streamlined, so it's not really complicated.
Yes.
I appreciate that.
Thank you, Senator West.
Yeah. Mr. Brown, thank you for bringing this to our attention. Thank you for coming today. All right. That's the end of invited testimony. All right. Invited testimony is now closed. Public testimony is open. Any registered public testimony? Chair calls Jennifer Fogg, John Warren, and Philip Clark. Public testimony. Please state your name, your position on the bill, and we'll give you 2 minutes. We'll start down on this end here and go this way.
Good morning again. My name is John Warren. I'm the county clerk for Dallas County. I'm also the president of the County and District Clerks Association. I come representing my association 253 other county clerks across the state of Texas, and we wholeheartedly support this bill that was so phenomenally produced by Senator West, who laid it out exactly. I want to make sure, if I can give you a little history, We have tried again and again and again, session after session in the legislature, where we thought we had nailed down the issue of fraud, but yet there continue to be instances where they be able to create hurdles to get over that. What this bill does, it provides a solution not just for the victim, it also provides a solution for the clerks. Senator Huffman, you want to know if it was a streamlined solution. It is extremely streamlined, and it makes it more efficient for individuals. And it is also a solution for the prosecutors who would now be able to do this based on the criminal code, being able to prosecute. Because on the civil side, that is just a slap on the wrist, and that is not enough. And so this gives us an opportunity to clarify, clean up this issue of property fraud and restore the victims. And there are always more than just one victim. There's the homeowner, and then there's the lending institution who's also a victim, and others. And so, and you talk about, I refer to it as, I believe it's a conspiracy, because you don't just have the one individual who's committing the fraud, but those who are actually facilitating. And so that makes it a more broader intent to commit harm on the original homeowner. I love the way that Senator West has laid this bill out, because I actually think it closes in every gap that we have missed over time, where we have learned those gaps that we've missed. But at the end of the day, this creates wholeness. It restores. You heard the victims. It restores money that through the restitution, money that they have lost in trying to get property back. It also restores generational wealth to those individuals who have lost it. I thank you for your time, and I'll entertain any questions you may have afterwards.
All right, go ahead.
Chairman, committee members, thank you for allowing me the opportunity to come before you today. I am Jennifer Fogg, and I am the Rockwell County Clerk, and I am here in support of this bill, and I appreciate Senator West for laying this out. I'm here for any questions.
Thank you. Yes, sir.
Good morning, Chairman Parker, members. Thank you for having me here. My name is Philip Clark. I'm here on behalf of John Creuzot, the Dallas County District Attorney, and I am here in support of SB 2611. And I want to thank Senator West for proposing this bill, because I prosecute cases involving deed fraud as a prosecutor in Dallas County, including the trial that you've already heard about from a witness earlier, Mr. Brown. In working these cases, I have seen a lot of patterns, and I have seen hundreds of properties just in our county alone. But if you'll notice in the handout that is circulating around, there are photos of various different properties that are the subject of this crime. This is only 14 photos. You can see that there are many different kinds of properties that have been the victims or have been used in deed fraud. A church, many churches actually, land, which belongs to another witness who testified earlier, Mr. Willis, commercial properties, homes, high-end homes, low-end homes, abandoned homes, lived-in homes. It can happen to any kind of property, and it can happen to any kind of property owner. This bill is aimed at making real property theft harder to commit, easier to investigate, better to prosecute, and easier for victims to have a tool to try and fix this on the civil side as well. I am part of the team that crafted the language before you, and I welcome any questions that you might have about the language of the bill, what it does, the various different, I'm calling it a soup to nuts bill, the various different ways that we're trying to approach this problem. And I hope that you will ask me any questions that you may have.
Thank you. Members, any questions of these witnesses? Quick question.
Yes.
I've heard of this area, but I'm not real familiar with it. I think it's a very important bill, and it's amazing to hear the number of instances of this. It's good that we're looking to create more deterrence through the, tougher laws and things. But is there anything systematically we can do just to stop it from at the very beginning?
As the county clerk, and the question would be, why would the clerk allow this to happen? And so, unfortunately, the law as it stands says that we're required to post a sign that says it's illegal to file a fraudulent document. And it says that we should make sure that the document is properly signed, make sure it has the grantor grantee, the legal description, and it is notarized. That's the extent that we can do. But we receive a document that has already gone through that process of creating a fraudulent document by a notary not doing their due diligence and making sure that the people that are before them, as you heard one of the witnesses say, are those individuals. If we can get more help on the front end by getting the notaries to do more, to put more effort into the documents they are notarizing, then that would be helpful. One of the things that we are doing, as clerks, we're not required to, excuse me, to index the notary. We're starting to do that, and we're going to start sending the notary, they list a report of all the documents that we have received, that they have notarized. If a notary see that if they know that they've notarized 20 documents in a month, but there are 30 documents on the list, they'll know that there's 10 documents that they did not notarize who could potentially be fraudulent documents. At that point in time, we can then reach out to the original homeowner and say, hey, we've identified an issue. We need you to see if this document is actually yours, and if it is not, then we can start the process of contacting the DA's office as the law requires in 51901, so that we can start the process of removing that fraudulent document.
Yeah, thank you. Well, it's not for this bill. This is an important bill as it stands, but it'd be interesting to go back and look at this more and maybe share those best practices like you're doing, and maybe there's something more, some more teeth we need to put into notaries. I don't know.
Mr. Chairman?
Yes, sir.
We have passed, this committee has considered, I think it was this committee, considered a notary bill that we put some additional teeth in, additional training in order to kind of nip this in the bud as fast as possible.
Sounds like a good idea. Yes.
Yeah, I would just add, though, that if it is more of a sophisticated, organized kind of crime, the notary, they're going to have their own notary. That's not going to really solve anything.
That's true.
I think we're naive to think that that's going to fix something if it's an organized, because it's very easy to have your own notaries and so forth, so it's not.
Well, Senator Huffman, to that end, a notary is an officer of the state through the Secretary of State, so.
Yes.
And I think, if you complain, if certain organizations, or if a lawyer gets complaints against them, he can refer them to they're being referred to the state bar. If a notary gets complaints, there should be a mechanism to say, okay, you're not doing your job. These are the things that we are seeing verified in court. Okay, so you're no longer be a notary. Turn in your notary seal to the county clerk, and we're done.
Consider has that bill passed, or was that other sessions, or?
It passed this committee about 2 or 3 weeks ago, I believe. So it's in the process.
There's a lot of bills that have come this
Right, exactly.
I'm sure I voted for it.
It's in the process right now.
Okay,
and
good.
let me say this to you. If there's a conspiracy that a notary is a part of, as you well know,
yes,
that's enhanced punishment,
exactly.
et cetera, et cetera. Yeah.
That's what I was sort of thinking of, yeah.
And to that point, if I may, Senator Huffman, the offenses that are created in this bill does nothing to eliminate any other offenses that would be available for prosecution for the conspiracy or engaging in organized criminal activity. And both of the chapters that these offenses are included in the engaging in organized criminal activity statute.
Good. Okay.
So that would be available if there is an organized.
Because looking at these photos, I don't know which one of you brought the photos, but anyway, you did. I mean, it's like shopping centers and big homes. Yes. It's not necessarily just the small elderly.
Right.
That's right.
I mean, big parcels of land. I mean, this is. Yeah,
that's right.
This is just a very small example.
And
it's not a big
Senator Huffman, and in terms of what we do with this bill that's different, address the civil section in terms of being able to get the property back and making it more easy. In terms of the efficiency piece, address that.
I'd be happy to. Section 4 and then sections 5 and 6 of the bill both address 51901 and 51903 of the government code. I call this affectionately the self-help statute. This is a beautifully written statute that provides a model motion for a homeowner to fill out and take to a court. It provides a model judgment, or really a findings of fact and conclusions of law, for a judge to then fill out based on what's presented to the judge.
And will this be available, that the model and so forth, like through the clerk's office? If they come to you, will you have something there? Is that part of the bill that's required for the clerks to provide that information? When
If I can, Senator Huffman, that's a great question. What we do, we actually extract the motion for judicial review from the statute, from 51903, as well as the findings and facts and conclusions of law. We created a form for the homeowner to use, instead of them having to go do that work themselves.
Perfect. Okay.
And if I may, 51901 and 51903, it is restrictive in how it's supposed to be applied. What the bill here does is it clarifies the language of those two statutes to track how they are interpreted by the courts, so that they don't give false hope in some instances. But there is expanded utility to the statutes in this bill, in that a judgment listing a fraudulent property, a criminal judgment that references a fraudulent document, that becomes a basis for presumptive fraud.
All right.
In and of itself, which is a huge step forward for victims. I will say, it's only for victims whose cases have gone to a criminal case with a prosecutor like me, to a court that ends in a conviction.
Correct.
But
which is going to limit the scope of some of
it
this.
does.
Because it doesn't address the issues that we heard from some of the first witnesses about, I think the lawyer who had investigated a lot of fraud or uncovered through a case of her own, a family law case, doesn't help necessarily those who approach police and so forth and kind of hit a brick wall.
Not
Or
until-
some counties maybe where the clerks aren't as informed as and working on the issue as much. So that's kind of my concern. I feel for these people just get lost in the system very quickly, which happens a lot.
Oh, yeah.
And that's. But it sounds like this bill brings this, as you call it, the self-help statutes forward, at least for those who have received a
It does,
conviction.
and it clarifies, because it will not apply in certain kinds of instances, but it reads like it does.
Yeah.
So where the bill, you see where we're changing the orders and where it said or and now it says and, because that's how the courts are interpreting it. So we're making the bill to read like it's interpreted so that it's more appropriate and more on point. However, that clarity alone is very helpful, even to victims who don't make it into the criminal system.
Okay.
Because again, it will no longer give false hope, and it'll help them or their attorney understand how and when to use this statute, because it doesn't apply in every situation. And if I could just say why it shouldn't, if it were too easily applicable, then we have a situation of seller's remorse, where a seller could abuse that and just say, oh, I could have gotten more money for that deal. I'm going to say that I didn't actually intentionally sell this and do this motion and unwind a deal. And we don't want to go that far.
All right. So it's a balancing. Yeah.
That's right.
Thank you.
Thank you. Any more questions of the witnesses? Thank all three of you for coming and lending your expertise. Appreciate it very much.
Thank you for having us.
Gotta help the people out.
Is there any more public testimony? Anyone else wishing to testify in this bill today? Seeing none, public testimony is closed, and we will leave this bill pending. The chair lays out SB 482, recognizes Senator Alvarado to explain the bill.
Good morning. Good morning. Thank you, Mr. Chairman and members. Some of you served on the task force that the Lieutenant Governor put forth after the Beryl storm, and we heard a lot of testimony about some of the challenges that many of our cities face, but we also heard about challenges that some of our frontline workers face, like our linemen, who were not only dealing with the challenges of restoring power, but also some harassment and in some cases some assault by the public. Senate Bill 482 would enhance protections for utility workers during a declared disaster or in areas with evacuation orders by increasing criminal penalties for offenses committed against them while performing their duties. These linemen come voluntarily. Some of them are coming from out of state. If they feel the risks are too great, they can just simply go home. As natural disasters like Beryl become more common, it is essential that we demonstrate our commitment to keeping them safe. When they are here for us, we're going to be there for them. Senate Bill 482 enhances protections for utility workers by increasing criminal penalties for offenses committed against them while performing their duties during declared disasters or in areas with evacuation orders. Assault is elevated to a third-degree felony, and harassment becomes a Class A misdemeanor under these conditions. Members, y'all may recall that many of us went out on our social media during Beryl to ask the public to please stop harassing, stop assaulting these linemen. We understand if you're upset with corporate folks, but these are the front linemen who are restoring power. And by assaulting them, by attacking them, you're delaying getting your power turned back on. We have some folks here from Centerpoint. We have IBEW here that represents many of the linemen that are doing this work that can talk about, and they have some pretty good stats about the increase that we've seen over the years, even in this year when we really haven't had a declaration or a natural disaster, but the increase in the number of incidents involving harassment, assault on linemen. Thank you.
Thank you. Members, questions, Senator Alvarado.
Thank you, Mr. Chairman. Will this also include utility workers, for example, when there's a flooding, a huge storm, you have people trying to unplug some of the water lines and sewer lines? Would that be included under the definition?
Well, there would have to be a declaration made by the president or the governor or your local municipality, like your county. For example, county judges can do that. But it also applies to the telecom, people who are working in that industry, and also let's see, I think that's, pipeline also are included in this as well, and telecom, and then, of course, our utility.
I just want to clarify and make sure it has a broad definition that it also includes workers who are sent out during any type of emergency by either the county, the city, or local government.
As long as it's called a declaration.
Thank you, Senator.
You're welcome.
Any other questions, Senator Alvarado? Do you have invited testimony? Okay. Oh, all right.
Yes, we have
Here calls
Centerpoint and IBEW, I believe.
Sam Chang and Donnie Mayo. Please state your name, your position on the bill, and you'll have 2 minutes each. We'll start with you and start here and go this way.
Good morning, Mr. Chairman and members of the committee. My name is Sam Chang. I'm a Director and Associate General Counsel at Centerpoint Energy. I am testifying on behalf of Centerpoint Energy and in support of SB 482. During mass power outages, utilities often rely on mutual assistance workers that come voluntarily to help employees and local contractors restore power. After Hurricane Beryl, for example, we had over 12,000 mutual assistance workers come voluntarily to help restore power. Unfortunately, and as referenced by Senator Alvarado, there were some incidents where worker safety was threatened and restoration was impeded. I can cite a few examples. Our staging site at Barnett Stadium had to be relocated due to a credible threat of a drive-by shooting. We had another employee that was threatened with a gun by a member of society, and that caused the relocation of 100 mutual assistance workers to somewhere else. And finally, we had a utility worker shot at with a BB gun by someone in the public. And so we're concerned that these kind of high-profile incidents have a chilling effect on mutual assistance workers' willingness to come help us in the future. Just as Centerpoint Energy would not want to put its employees and contractors in unsafe areas, our mutual assistance partners likewise would not want to do so either. And so that's why we do support SB 482.
Very good. Thank you, sir.
Yes, Donnie Mayo, IBEW Local 66 business representative. I represent our roughly 5,000 members right there in the Houston, South Texas area, along with the mutual assistant guys that come into town. As he was speaking of the Bartlett Stadium issue, the crews that were assigned there were saying they were going home if we couldn't do something for them. So we had to move them roughly 15 miles further away from the work area that they were in. So now that takes them longer to travel back into town to where they're going to work, which slows everything down. And not only slowing them down with the travel, but the days to relocate. You know, 25 to 3,000 people in that staging area. It just slows the whole process down. Our linemen, they're out there and they're busting their butts, excuse the language, but they're busting their butts to get the power back on for these people. And we need to protect them when they're out there. And I am very much in support of this bill.
Thank you very much. Members, any questions of these witnesses? I think it was pretty clear. Thank you. Thanks, both of you. Do you have any more invited?
I don't believe so, but I know that there are some organizations that submitted cards in support of the bill. I believe AECT, City of Houston, and maybe another. Y'all should have those, I believe.
This is invited? Public, okay, all right. Okay, very good. Invited witnesses is closed. Testimony closed. And we'll pass it back over.
Well, you're doing such a good job.
Okay, great, thank you. All right, very good. All right.
Thank you very much.
Yeah, you bet.
Thank you, Senator Hagenbu, for doing that for a while. Sure it was good, entertaining. No, thank you for all seriousness. Chair now opens up for Senate Bill 482 for public testimony. The chair calls Taylor Kilroy. Taylor Kilroy.
Morning.
Morning. Please state your name, who you represent, your position on the bill. You have 2 minutes.
Thank you, Chairman Flores, Vice Chair Hagenbu. I'm sorry, not Vice Chair. Vice Chair Parker, if he was here. Members and staff, my name is Taylor Kilroy. I'm the Executive Director of the Texas Public Power Association, and I'm testifying in full support of Senate Bill 482. This isn't our usual committee, so TPPA represents the 72 municipally owned electric utilities and other publicly owned electric systems that provide power to over 5 million Texans. In addition to our work here at the PUC and at ERCOT, we're also responsible for coordinating in-state and national mutual aid response. For instance, during Hurricanes Helene and Milton, which devastated Florida and Georgia, we were able to send crews out, including from Kerrville and from Denton, to help those small systems recover. During Beryl, we were also able to send out crews to help some of our East Texas towns. And without a doubt, without exception, our crews were treated with the utmost respect and appreciation. However, that wasn't always the case. And as you heard from Senator Alvarado's layout, particularly in Houston during Beryl, that was absolutely not the case. Stories of utility workers being robbed at gunpoint or otherwise threatened quickly traveled across the industry. And I've been told by my counterparts who run similar associations in other states that it will be a very hard sell to send utility crews for mutual aid response to Texas in the future. To be frank, I am very worried about the next natural disaster, and I am not confident today that we'll be able to procure enough mutual aid response to help get people powered on as soon as possible. Mutual aid response already asks our utility workers to travel across the country, leave their homes, leave their families, and drive directly into a disaster zone. The work is already dangerous enough without the potential for threats and injury from the people they're there to help. SB 482 serves as a powerful message that the kind of behavior we saw during the Beryl response will not be tolerated, and we're fully supportive of the bill. Appreciate the opportunity. Thank you.
Thank you, members. Any questions? Thank you very much for your testimony. I see no one else has registered for public testimony. Is there anyone here present which to testify on, for, or against Senate Bill 482? Hearing none. Public testimony is closed. We'll leave the bill pending. Chair lays out Senate Bill 1234 and recognizes Senator Hancock to explain the bill.
Yes, thank you, Mr. Chairman. As you know, fentanyl is a very deadly substance. Exposure continues to be a growing issue. This legislation is brought to us by Sheriff Wayborn, the county sheriff in Tarrant County. We as a legislature have taken a measure to combat it, but Senate Bill 1234 takes aim at tackling the unaddressed aspect, protecting our vulnerable populations of children, the elderly, and those who are disabled from exposure to it. The current statute provides that if someone places a child, elderly individual, or disabled individual in imminent danger of death, bodily injury, or physical or mental impairment by exposure to methamphetamine through any of several different ways, then such an offense is a state jail felony. Senate Bill 1234 brings a penalty group 1B to the existing statute. Penalty group 1B is fentanyl and related opiates. With this, we will strengthen protections for children, elderly individuals, and disabled individuals by expanding the penal code for endangering these vulnerable populations through the use or exposure of fentanyl. So it's just adding fentanyl to the 1B classification, or that grouping of opiates.
Members, any questions? So invited testimony for Senate Bill 1234 is open. The chair calls Lauren Lawrence. Lauren Lawrence. Good morning. Please state your name, who you represent, your position on the bill, and proceed.
My name is Lauren.
You'll need to turn the mic on real quick. They may have to do it up there. There we go.
There we go. Good morning, Chairman Flores. My name is Lauren Lawrence. I am here on behalf of the elected district attorney of Tarrant County, Phil Sorrells, and we are in favor of this piece of legislation. Thank you, Senator Hancock, for sponsoring this and bringing this forward to the committee. Ultimately, what Senate Bill 1234 does is add penalty group 1B substances to the presumption that the state gets in the endangering statute that says that we just presume that fentanyl will cause serious bodily injury or death if these communities are exposed to it. So it doesn't actually change who can be charged with this offense or the circumstances under which we can charge it, simply the fact that if there is an exposure to this substance, it is now presumed under the law that it can cause serious bodily injury or death. And so I'm happy to answer any questions the committee may have.
Any questions, members?
And this did come from the DA's office rather than the next one came from Sheriff Wayborn. So,
okay. Thank you. I'm pretty sure a quorum is present. With that, thank you very much.
Tell DA Sorrells I said hello.
I see there's no one else listed in invited testimony. Invited testimony is now closed. Chair now opens for public testimony. The chair recognizes Kirsten Budwine. Kirsten Budwine. Good morning.
Good morning.
Your name, who you represent, position on the bill. You have 2 minutes.
Yes, sir. Good morning, Chairman and members of the committee. My name is Kirsten Budwine. I'm a policy attorney with the Texas Civil Rights Project here in opposition to SB 1234. While we understand the intent to protect vulnerable Texans, this bill is a step in the wrong direction. SB 1234 creates a legal presumption of child endangerment based solely on the presence of certain controlled substances, regardless of actual harm or intent. This presumption is overly broad and risks further criminalizing people based on circumstances that may not be within their immediate control, including those with substance use disorders. We've seen where this approach leads. For decades, the war on drugs has prioritized punishment over treatment, tearing families apart and disproportionately targeting marginalized communities, all without delivering on the promise of safe or healthier societies or communities. This bill continues down that same path, a path that criminalizes illness instead of addressing it with compassion and care. Rather than presuming guilt and increasing incarceration, we should be investing in proven strategies like access to mental health care, substance use treatments, and family support services. These are the tools that truly protect children, support families, and strengthen communities. SB 1234 risks doing more harm than good, and for these reasons, we are opposed to the bill. Thank you.
Thank you, members. Any questions? Questions? Thank you very much for your testimony.
Thank you.
Yeah, a lot of questions.
I see no one else registered to testify public testimony, so public testimony is now closed. We'll leave the bill pending. Chair calls out, lays out Senate Bill 2580 and recognizes Senator Hancock to explain the bill.
Yes, thank you, Mr. Chairman. This one is recommended from Sheriff Wayborn in Tarrant County. As you know, pings or emergency signals given from your phones, and law enforcement have the availability to do this, really, but right now only in Harris County, and it's the only one able to. And so TDCJ's office, the Inspector General, TJJD's office, the police department, these are available in Harris County. What this bill does is it drops that bracket so that it picks up the 12 largest counties that can utilize this as well, rather than just it being Harris County only. That's what it does.
Thank you. Members, any questions? Senator Hinojosa.
I guess I'm just looking at the bill itself. You still have to get a court order to be able.
Yes, it doesn't change any of the stipulations. We're simply taking the statute that Senator Huffman passed, and we're dropping the population so that it picks up our 12 largest counties, including Tarrant County.
Thank you for answering my.
And I don't think there's been any issues with it in Tarrant County. I think it's been very useful, which is why we're looking at lowering population numbers.
No more questions. Invited testimony in Senate Bill 2580 is now open. Chair calls Sheriff Brian Hawthorne.
Thanks for coming down.
Morning, Sheriff.
Good morning, Chairman.
Name, where we represent, position on the bill, and you may proceed.
I will be brief. My name is Brian Hawthorne. I'm the Sheriff of Chambers County, just east of Houston. I'm here also representing the Sheriff's Association of Texas. We appreciate Senator Hancock for bringing this bill forward. There were abuses many years ago, part of why Senator Huffman brought that bill forward. I think those abuses have been taken care of. We're trying to lower that population so that sheriffs, many times when these emergency locators are used, some people call them pings, whatever, is usually trying to locate children or possible kidnap suspects, and time is of the essence. So we're just trying to bring that threshold down so that those sheriffs in those larger counties can act quickly. The rural counties will still have to reach out to the rangers or whoever to work through those, and then maybe as the years go by, we can even reduce some of that. So, but that's essentially, and I'll take any questions.
Members, any questions? Thank you for your testimony. Good
No,
to see
thank you.
Seeing no one else registered for invited testimony is closed. Chair now opens for public testimony. I see no one registered for public testimony. Is anyone here present wish to testify on, for, or against Senate Bill 2580? Hearing none, public testimony is closed. Chair will leave this bill pending.
Thank you. Thank you, Mr. Chairman.
Chair lays out Senate Bill 659. Chair sends up committee substitute for Senate Bill 659. Any objection to adopting the committee substitute for Senate Bill 659? Hearing none, so ordered. Recognize Senator Schwertner to explain the bill and the substitute.
Thank you, Mr. Chairman. Members, this bill is about the offense of human smuggling in the Texas Penal Code. The bill as filed applied a first-degree felony charge to individuals who use government resources to commit human smuggling, specifically when encouraging unlawful entry into the country, and emphasized that Texas will not tolerate the misuse of Texas taxpayer dollars, especially by those entrusted not only with government resources, but also with an official duty to the public. The committee substitute enhances the human smuggling definition to capture anyone who directly or indirectly assists or directs the use of a vehicle, whether it's motor, air, or water, for human smuggling, including covers, lookouts, coordinators, and others behind the scenes who currently evade charges. This change provides stronger legal tools for prosecutors to charge everyone involved in the smuggling operation, not just those physically present. Further, the committee substitute expands the definition to anyone assisting, guiding, or directing a single individual, rather than two or more, to enter or remain on public or private property. This directly addresses how cartels have adapted to avoid detection and prosecution, ensures that any smuggling offense, if committed with the use of government resources, has the enhanced penalty of a first-degree felony. In summary, the committee substitute Senate Bill 659 takes a firm stand against human smuggling by closing legal loopholes, broadening property-related statutes to disrupt cartel operations, and strengthening accountability for anyone involved. It ensures that Texas will no longer tolerate cartel corruption within its most trusted institutions. There is a resource witness from the Texas Public Policy Foundation. I'll be happy to answer any questions.
Senator Hinojosa.
Thank you, Chairman. I guess, for example, you may have a Texas National Guard along the border, and they may use some of their military vehicles to smuggle people from Mexico, coming from Mexico or other countries for that matter. Is this what you're trying to target in this?
That is one. There's actually been county resources and actual U.S. military resources that have been used in aiding and abetting human smuggling.
Yeah, and I know there have been issues and instances where they have used law enforcement vehicles to conduct some of this illegal human trafficking and smuggling. Okay. Thank you, Vice.
Yes.
Thank you. Any other questions, members? If not, the chair now opens it for invited testimony. Chair calls Ammon Blair. Your name, who you represent, and position on the bill, and you can proceed.
All right, good morning, Chairman Flores and members of the committee. My name is Ammon Blair. I'm a senior fellow at the Texas Public Policy Foundation, and I am testifying in support of Senate Bill 659. I bring with me 22 years of military service and extensive border security experience from my time in the U.S. Army and as a Border Patrol agent. Throughout my career defending the United States from transnational threats, I have witnessed firsthand the grim reality of cartel infiltration. This is not speculation. It is not exaggeration. It is a cold and brutal truth. Some of my colleagues, fellow agents and soldiers, were actively working for the enemy. So imagine conducting counterterrorism operations overseas, clearing buildings, maneuvering through hostile terrain, securing objectives with a battle buddy you trust with your life, only to discover he's been feeding intelligence to the enemy. He's told them where to strike, how to evade your unit, and when to attack. That is not a hypothetical. That is the reality we face right now here at home in Texas. Mexican cartels are foreign terrorist organizations, and they are waging a war against us from within. What happens when a soldier realizes, or an agent or a law enforcement officer, that his battle buddy, his partner, the one who's supposed to guard his life, is actually working for the enemy? It shatters morale, it breeds suspicion, it sabotages missions, and it puts every honest agent, soldier, and officer in mortal danger. We weren't just fighting cartel operatives, we were fighting a war with enemies embedded in our own ranks. Cartels operate like foreign intelligence services. This isn't just corruption, it's counterintelligence. They identify, target, and compromise public officials exactly as a hostile nation state would. They don't merely offer bribes, they use blackmail, coercion, and threats. Once an agent or soldier takes their money, they are owned. And if they try to walk away, their families become a target. Now, Sheriff Roy Boyd was going to come and testify today. He is the Operation Lone Star Task Force Commander, and which oversees 56 law enforcement agencies across the state. And he asked me to share this testimony, or this story real quick, which is actually where I served as a Border Patrol agent. In 2015, I was working on the Beltran case with Homeland Security Investigations. The case was centered around the Rio Grande City area, where we executed 3 search warrants on the smuggling organization. Afterwards, we discovered that some local law enforcement officers filmed our raids on their cell phones and broadcast it live to the cartel members in Mexico. After HSI returned to arrest the officers for their actions, investigation revealed that numerous officers in the area were actively supporting cartel and cartel operative smuggling operations. Some officers even made unrecorded traffic stops on persons the cartel wanted kidnapped, so that cartel operatives could take the person from the stop. This guaranteed a swift kidnapping. Both myself, Texas Public Policy Foundation, Sheriff Boyd, and his Operation Lone Star Task Force are in full support of Senate Bill 659. And thank you, Senator Schwertner, for acting on this important matter.
Thank you, members. Any questions?
Question?
Senator Hagenbu.
I really appreciate this bill. It's really important. I can't believe, hard to believe that this would happen. That someone would, a service member, National Guard, U.S. military would do this. Do you know what's the penalty in the U.S. military for this kind of action? It's treason, right?
Yes, sir. Now that they're designated as foreign terrorist organizations, it is treason. But before, it wouldn't be counted as treason itself. It would just be counted as a misdemeanor or whatever the state or federal penalty that they decide, whether that's the U.S. Attorney's Office or the state.
What's the penalty in the U.S. military for treason?
Life in prison, death.
Mm-hmm. Yeah. Firing squad, I think.
Yes, sir.
Yeah. I'm glad to see that we're increasing the seriousness of the.
Yes, sir. And like I said, I'm grateful for Senator Schwertner for making this and also making adjustments on the language. National Guard, as you guys know, also operate within our talks in the Border Patrol Center. So it's not just that they're located inside the vehicles smuggling. They also are inside of our talks with camera systems across the entire border. And so they have access or known access to where every agent is, where the gaps are along our border. And so they coordinate also from there as well. And they have been coordinating each station along the border. So I'm grateful for Senator Schwertner for also adjusting that and also adjusting the language in terms of this doesn't just happen on ranch roads. This happens across the entire border and throughout the state. It happens in suburban and rural areas. It happens also in urban areas as well.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you. Thank you for your testimony.
Thank you.
As Chair sees no more invited testimony, so invited testimony is now closed. Chair now opens over public testimony. Chair calls Daniel Woodward. Good morning. For the record, your name, who you represent, your position on the bill. You have 2 minutes.
Good morning, Chair Flores, members of the committee. My name is Daniel Woodward, and I'm a policy attorney with the Texas Civil Rights Project, and I'm testifying in opposition to the bill as filed today. I haven't had a chance to look at the committee substitute. But I understand from the layout and bill analysis that the bill is aimed at combating cartel corruption of government resources, and that's not what our concern with this bill is. We just want to bring up a potential unintended consequence and hope that we can work together with Senator Schwertner's office to maybe revise the language a little bit and get to a place where that unintended consequence isn't a concern. The concern is really that this could increase the targeting of nonprofit organizations that serve vulnerable migrants. Over the past few years, a number of investigations have been opened against nonprofits who are called by their faith to give humanitarian aid to migrants under this very code, and they've been accused of harboring or sheltering people using government resources. For example, the state alleged that a shelter in El Paso was sheltering or concealing people by providing beds for them, in some cases even after they had been released by ICE and were brought right to the shelter for temporary stays. These charges were false, and a judge has stated that the investigation was a pretext to justify harassment. And it cost an enormous amount of money for these organizations, and it also causes fear among the community of people whose faith do call them to serve vulnerable migrants. So we're concerned that adding the government resources language will send a message, intended or not, and I don't think that it is intended, that these political investigations are warranted or encouraged. And we do think that there are some tweaks to the language. I think somebody has shared them with you already, that we could make that could alleviate our fears and would also further the goals of this bill. So that's my testimony, and thank you.
Senator Hinojosa.
Thank you, Mr. Chairman. I don't think the intent of the bill is to target nonprofits.
No.
And I don't, do nonprofits use government vehicles?
They don't use government vehicles. The language that I saw in the bill says government resources, and some of them do get aid from FEMA, for example, and in some cases there are various county or local programs that might also give them.
And some of them receive grants from the government, so that would be, under the way you read it, read the bill, that would be broad enough to also include nonprofit.
That's right. And I think we could limit it a little bit.
Thank you.
Thank you. Thank you for your testimony.
Thank you.
As I see no one else has registered for public testimony, is anyone here present who wishes to testify on, for, or against Senate Bill 659? Hearing none, public testimony is closed, and we'll hold this bill pending. Thank you, Senator Schwertner. You ready? Yeah. Chair lays out Senate Bill 816. Chair sends up the committee substitute for Senate Bill 816. Is there any objection to adopting the committee substitute for Senate Bill 816? A, hearing none. So ordered. Recognize Senator Huffman to explain the bill and committee substitute.
Thank you. Members, currently, Texas law places constraints on law enforcement's ability to obtain electronic consumer data in urgent, life-threatening situations when a criminal investigation is not underway. To address this, the committee substitute to Senate Bill 816 creates an exception for disclosure in immediate, life-threatening situations, allowing providers of electronic communications and remote computing services to disclose electronic customer data with government entities if the provider, in good faith, believes there is an immediate threat to life to assist in preventing any death or serious bodily injury. Committee substitute clarifies that a person cannot take legal action against providers or their officers, employees, or agents for disclosing electronic customer data to a governmental entity as authorized by law. By removing the constraints of existing tracking statutes and aligning Texas law with federal standards, the committee sub to Senate Bill 816 provides law enforcement with additional tools they may need to respond effectively to life-threatening situations and prevent potential tragedies.
Members, any questions? Any questions? Hearing no questions, the chair now opens up for invited testimony. I see there is no one registered for invited testimony. Invited testimony now closed. Chair now opens for public testimony. Chair calls Gary McDonald and Kathy Mitchell. Gary McDonald and Kathy Mitchell. We'll begin with you. Good morning. Your name, who you represent, your position on the bill. You have 2 minutes.
My name is Kathy Mitchell. I'm with Equity Action. And Senator, I came by yesterday to try and find out what the committee substitute looked like, but y'all weren't, yesterday was a holiday, still, sort of. So I'm testifying a bit hypothetically, having seen the committee substitute in the House for the companion. So in part, my testimony is against a substitute I haven't seen, so I apologize for that. The concern that we have is that the substitute could create a protection, a liability protection for cell phone carriers. And I think that the way that the bill is worded, it's designed to be interpreted narrowly and within the scope of the constitutional decisions that have provided the framework for the disclosure of cell phone contents and cell phone metadata. And as you know, there's been very significant U.S. Supreme Court decisions guiding all of that in recent years. My concern is that if we give the cell phone carriers liability protection, that they will voluntarily interpret the words on the page as broadly as they want, and voluntary release of information isn't guided by the laws that guide subpoenas and warrants. And so with liability protection, I believe that there would be an overly broad interpretation by cell phone carriers of the private information that they could voluntarily disclose under this statute. And I'm not sure what we would do about that. So sight unseen, I just wanted to lay out that concern.
Thank you. Thank you for your testimony. Mr. McDonald?
Okay. Good morning. My name is Gary McDonald. I'm here on behalf of John Creusot, the District Attorney for Dallas County. I'm a Deputy Chief Prosecutor with his office in my 15th year there. I've been a Deputy Chief for 8 years. I want to start by thanking Senator Huffman for bringing this very valuable legislation forward and authoring it. Having worked with you in the past on G1 and locking down our statute, it's a pleasure to be back here and before this committee. The purpose of this legislation is to create a provision in Chapter 18B of the Code of Criminal Procedure, clarifying that under Texas law, a provider may voluntarily disclose in emergency situations electronic customer data in non-criminal circumstances to our agencies when the provider has a reasonable belief that such a situation exists. and the disclosure should be made without delay because of the emergency. These situations may include critically missing children, people who suffer from illnesses such as dementia or Alzheimer's, children or people who may suffer a medical condition and who are missing, and that without proper medication may be placed at critical risk of injury or death, or people that because of disease or disability may be placed at serious risk from their circumstances. Federal law already contains such a clear authorization in 18 U.S.C. 2702. This legislation differs from the existing provisions in G1. I want to make that clear. That is law enforcement requiring this disclosure. This is a provider determining that they have a reasonable belief to make the disclosure either based on their information or information provided to them. And if we end up in a situation where it turns to be criminal, they are constrained because we reset to subchapter G1 and suppression applies. I heard a little bit of testimony concerning liability. There are already some provisions in Chapter 18B, and I think the committee sub just clarifies some provisions. So I'm happy to answer any questions to clarify either the existing statute or the proposition. And I thank you for your time.
Thank you. So your position on the bill is?
We're in favor of this bill.
Thank you. Members, any questions? Thank you. Thank you all for your testimony.
Thank you very much.
So seeing no one else registered for public testimony, is there anyone here really wanting to testify on, for, or against Senate Bill 816? Hearing none, public testimony is closed. We'll leave the bill pending. So the chair lays out So Senator Hagenbu, are you going to be doing Senator Colcourt's bill? Okay. So the chair lays out Senate Bill 739 and recognizes Senator Hagenbu to explain the bill on behalf of Senator Colcourt.
Thank you, Mr. Chair. Members, yes, Senator Colcourt asked me to lay this bill out, and I appreciate the opportunity to do that. SB 739 adds an investigator commissioned by the Commissioner of Insurance into the section of code that allows peace officers to install and use tracking equipment for the purpose of fighting fraud. There are existing peace officers who already perform this duty, such as sheriffs, constables, a law enforcement officer commissioned by the Alcoholic Beverage Commission, the Parks and Wildlife Department, or any officer of the Department of Criminal Justice. Currently, TDI must collaborate with these officers in order to find out the information they need for their own investigations into fraud. SB 739 removes the condition that slows down TDI investigations for the purpose of government efficiency. And that's the layout, so thank you, Mr. Chair.
Any questions? Also, so Senator King is present. If not, the chair opens invited testimony. The chair sees no one registered for invited testimony. Invited testimony is now closed. Chair now open for public testimony. The chair calls W. Tyler Hampton. W. Tyler Hampton. If you state your name, who you represent, your position on the bill, you have 2 minutes.
Yes, sir. Mr. Chairman, my name is Tyler Hampton. I'm a captain with the Texas Department of Insurance Fraud Unit. So we are in favor. Mr. Chairman, members of the committee, I'd like to thank opportunity for each of you with the opportunity to discuss this amendment today. The Department of Insurance Fraud Unit, we're the law enforcement component of TDI, charged with protection of the public from economic harm through investigation and enforcement of insurance fraud and other crimes committed during the course of the business of insurance. We're currently employ 24 full-time peace officers. Our officers investigate a variety of crimes ranging from insurance fraud to money laundering and organized crime. Despite the fact that we're sworn law enforcement officers commissioned by the state, our peace officers are not included on the definition of authorized peace officer under Code of Criminal Procedure 18B001. Business of insurance is routinely conducted online today, whether it involves applying for an insurance policy or submitting a claim. Most offenses investigated by the fraud unit now involve some element of electronic communications made via social media and other messaging applications. Insurer claim submission and application portals, email, mobile devices, etc. The fraud unit's exclusion from the list of authorized officers by the statute to obtain electronic customer data poses a significant challenge to our investigative activities.
When a fraudulent insurance act occurs online, an investigator must prove where it occurred in order to establish proper venue for a criminal referral. We must also obtain sufficient evidence as to the identity of the person or persons who committed the act. Both of those elements require the access to the electronic customer data to identify the person using a applicable service and information about their use of that service. Currently, our investigators have to rely on outside support, as was stated before, to obtain the necessary electronic customer data. That reliance needlessly prolongs our investigations, which allows suspects to continue victimizing Texas insurance consumers and companies, causing greater economic harm.
Thank you for your testimony. Members, any questions? Thank you very much. I see Chair sees no one else registered to testify publicly. Is there anyone here wishing to testify on, for, or against Senate Bill 739? Hearing none, public testimony is closed. We'll leave the bill pending. So Senator King, I think you're going to also be laying out a bill for Senator Sparks. Is that correct?
Yes, Chairman, that's correct.
Would you like to do that one?
I'll be happy to.
Chair lays out Senate Bill 1886 and recognizes Senator King on behalf of Senator Sparks to explain the bill.
Thank you, Mr. Chairman. This bill is a simple but important update to our criminal procedure statutes. It would allow any peace officer to execute a search warrant for a blood specimen in any county adjacent to the one where it was issued. The change is particularly relevant in cases involving intoxication-related offenses where time and officer availability are critical. Currently, a search warrant for a blood specimen in an intoxication offense can only be executed by an officer authorized to make arrests in the county where the warrant will be executed. This restriction creates logistical and operational problems for many law enforcement agencies, especially those that contract for jail services across county lines. This bill removes the language in current law that requires the executing officer to be authorized to make an arrest in the county of execution. This resolves the issue and ensures that peace officers can carry out these warrants efficiently, regardless of county boundaries, so long as the warrant is executed in a county adjacent to where it was issued. And I was reading an example he's got back here that explained it to me. It says, for example, the city of Addison, which is located in Dallas County, contracts with neighboring Tarrant County for jail services. If an Addison officer arrests someone for DWI and the suspect refuses to voluntarily provide a blood sample, the officer must take several steps. First, they drop the blood suspect off at Tarrant County. Then they drive back to Addison to draft the warrant, locate a Dallas County magistrate to obtain it, return to the Tarrant County jail to retrieve the suspect, bring them back to Dallas for the blood draw, and then return them back to Tarrant County jail. So anyway, with that, I understand he has a resource witness.
Senator Hagenbu, you have a question?
No.
Thank you. Invited testimony is now open. Chair calls T.J. Smetzer. Good morning.
Good morning.
Your name, who you represent, your position on the bill, and let me begin.
Yes, sir. My name is T.J. Smetzer. I'm an assistant chief with the Addison Police Department, and we are for this bill. Thank you to Senator Sparks for filing this bill and to Chairman Flores for calling this committee hearing. The Addison Police Department does not currently have our own city jail. Instead, we contract with a city in northern Tarrant County to provide jail services, while Addison is completely within Dallas County. Whenever we arrest someone for DWI, if they don't consent to providing a blood specimen, we first transport them to the jail in northern Tarrant County, book them in, type up a DWI blood search warrant, drive the arrested person back to Dallas County to actually execute that blood warrant. As you know, in a DWI, time is of the essence, and obtaining the blood evidence as quickly as possible is crucial. We spend at least an extra 30 minutes driving because we currently cannot execute blood warrants outside of Dallas County. Additionally, the closest Level 1 trauma center to Addison is in Plano in Collin County. Whenever we have a DWI major accident, often the injured are transported to this hospital in Plano. While state law currently allows us to obtain a DWI blood search warrant, it doesn't allow us to actually execute it in Collin County. In these situations, we must call a Plano police officer or even a state trooper over to assist with executing the search warrant. This very small change to the law will allow us to execute blood warrants in neighboring counties, and I'm happy to answer any questions you might have about the bill.
Members, any questions? Thank you very much, and thank you for your service.
Thank you, sir.
The chair sees no other invited testimony, invited testimony is now closed. Chair now opens for public testimony. There is no one registered for public testimony on Senate Bill 1886. Chair, if there's anyone present wish to testify on, for, or against Senate Bill 1886, hearing none, public testimony is closed. We'll leave the bill pending. Senator King? It's a pending bill. We'll come to that when we come to the vote.
I'm ready. Okay.
Chair lays out Senate Bill 2693. Recognize Senator Huffman on behalf of Senator Perry to explain the bill.
Thank you, Mr. Chairman. I'm pleased to lay this out for Senator Perry. Members, current law requires that the Texas Juvenile Justice Department shall allow advocacy groups into department facilities. However, current law does not allow TJJD to evaluate whether or not the services provided by the advocacy group are in the best interest of a juvenile. SB 2693 states that TJJD may allow an advocacy group into a facility if the services the group provides are in the best interest of a youth committed to the department. Additionally, the bill requires TJJD to deny admission to an advocacy group that has filed a complaint with the federal government regarding the department while the investigation is pending, or a lawsuit against the department while the lawsuit is pending. That's the bill.
Any questions, members? Any questions? Hearing none, the chair now opens for invited testimony. There's no one registered for invited testimony. Invited testimony is now closed. Chair now opens for public testimony, and the chair calls Elizabeth Henneke. Elizabeth Henneke. I hope I pronounced that correctly.
Yes, sir. I think you may know my brother-in-law, Rob.
So
Hi,
please,
everyone.
does your name, who you represent, your position on the bill, and you have 2 minutes.
My name is Elizabeth Henneke. I am the Executive Director and CEO of the Lone Star Justice Alliance. I'm here to testify on the bill because we represent kids in the Texas Juvenile Justice Department, and I've been asked to come speak to you guys about some concerns that we have about this bill and this language. In 2022, Governor Abbott asked us to start working with survivors of child sex trafficking in the Department of Juvenile Justice. I worked with Andrea Sparks in the governor's office and began going into the units to represent those kids. When we did, we found that TJJD did not have an adequate way of allowing entry for attorneys. We were designated as quote-unquote advocates, even though we were actual attorneys. All of us are licensed in the state of Texas, most of us with more than 15 years. We had been given a grant by the governor's office to go in and represent them. And we found that the process was extremely confusing for who is an advocate, who is an attorney. So we're on the bill because we think there does need to be clarity. We think that there is a lack of communication and clarity between an advocate and an attorney. I am concerned, though, about an agency being a gatekeeper to legal services. On at least one instance, the agency attempted to inquire with our attorneys what the scope of our representation was, what we were looking to do on behalf of the child, And we thought that it went into pretty aggressive questioning that was on privileged matters between us and our client. Ultimately, we resolved the matter with the agency and with the Office of Inspector General, but it created an ethical challenge for us when we had kids that were coming in and talking to us about their cases, and we were being screened at the front door about entrance.
Thank you very much for your testimony. Any questions, members? Senator Huffman?
No, I just had my light on. I'm looking, of course, this isn't my bill, but I'm looking through it. I don't think there's anything in here that would prevent a juvenile's attorney, their attorney, from being allowed to visit with their client. So I guess your concern is that if you're an attorney but you're part of an advocacy group, you think you should be exempted, which I'm not sure I agree with that. So, but if you are, I'm certain, looking at this language, I think I can speak for Senator Perry. If you are the juvenile's attorney, this does not apply to you. So,
Can I just raise one concern, Senator?
you can raise it, but I'm not the sponsor,
Yeah.
so.
And that's fine. And we've communicated with Senator
sure
Perry
you
our
have, yes.
concerns.
Okay, good.
So happy to move on.
Thank you.
Thank you. Thanks.
Thank you for your
I
testimony.
appreciate you all.
Chair sees no one else registered for public testimony. Is there anyone here wishes to testify on, for, or against Senate Bill 2693? Hearing none, public testimony is closed, and we leave the bill pending. Members, I think we're ready to vote these bills out if you all are ready. Senator Hinojosa, you're okay with you? Chair moves that Senate Bill 127 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman,
Aye.
Senator Miles, Senator King,
Aye.
Senator Hagenbu.
Aye.
5 ayes, no nays.
There'll be 5 ayes and no nays. Senate Bill 127 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu recommends Senate Bill 127 be recommended local and uncontested calendar. Any objection? Hearing none. So ordered.
If you don't want to call up, Louis, you left it open because there were witnesses back there.
So the chair opens up for consideration Senate Bill 456, and there was some procedural things we got to do here. So to close this bill out, so is the invited? I think it was left at invited testimony, and if the chair calls Jesselyn Nguyen and Ron Burnett. Good morning. Your name, who you represent, your position on the bill, and you may proceed.
Good morning, Chair Flores, and good morning, committee. My name is Ron Burnett, and I am with Combating Global Organ Trafficking, and I am a board member there. We strongly support this bill on human trafficking. Trafficking people for the purpose of harvesting, transporting, and selling human organs is one of the least detected and unreported forms of trafficking. Nevertheless, just last year, the U.S. Department of State warns it may be rising. What is human organ trafficking? Trafficking in persons for the purpose of organ removal is a form of trafficking in which an individual is exploited for their organ, including by coercion, deception, and abuse of a position of vulnerability. Because of this, we at Combating Global Organ Trafficking believe it is imperative tough legislation is passed to help deter such criminal activity in the state of Texas. Thank you for your time.
Thank you for your testimony. Any questions, members? Ms. Nguyen?
Good morning, Chair Flores and the committee. My name is Jesselyn Nguyen. I'm a professor of criminal justice, also executive director of Combating Global Organ Trafficking organization, and I'm here to support strongly SB 456 for the reasons below. Seriously, the crime of human organ trafficking is the most dangerous crime on earth that violates the human dignity's principle of justice and respect. Legally, about 10% of human organs being supplied for organ transplantation. And in America, average daily, more than 20 patients die while they're waiting for organ. And due to the demand and supply, as of 2023, according to the U.S. Department of Health and Human Services, more than 46,000 organ transplantations procedures performed, while only 17,000 human organs donated by both living and deceased donor. So the big question here is, where's more 28,000 organ humans coming from? So in other words, 62% of humans' organ came from the black market, which controlled by organized crime. So according to my scientific research that has been accepted by Senator Middleton, if you would like to have more information about or organ trafficking, please, I will provide you about my scientific research. But I, again, testify today and strongly support SB 456 in order to criminalize this type of crime that is not classed as misdemeanor according to Chapter 48, Section 2, Texas Penal Code. So it should be a felony, or maybe first degree, or whatever, that we can stop this type of crime and protect our community, put people in the safety place. That's right. Thank you.
Thank you. Any questions, members? Thank you all very much for your testimony.
Thank you, Chair, and the committee.
The chair sees no more invited testimony, so invited testimony is now closed. Chair now opens up for public testimony. Chair sees no one registered to testify publicly. If there's anyone present who wishes to testify on, for, or against Senate Bill 456, hearing none, public testimony is closed. Chair moves that Senate Bill 456 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King,
Aye.
Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes, no nays. Senate Bill 456 will be reported to the full Senate with a favorable recommendation. Senator Huffman recommends Senate Bill 456 be recommended for local uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that Senate Bill 482 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and no nays. Senate Bill 482 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends that Senate Bill 482 be recommended for local and uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that Senate Bill 659 do not pass, but that the committee substitute for Senate Bill 659 be adopted in lieu thereof, be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and no nays. The committee substitute for Senate Bill 659 will be reported to the full Senate with a favorable recommendation. Senator King recommends the committee substitute for Senate Bill 659 be recommended for local and uncontested. Any objection? Hearing none, so ordered. Chair moves that Senate Bill 739 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and 0 nays. Senate Bill 739 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends that Senate Bill 739 be recommended for the local and uncontested calendar. Any objection? Hearing none, so ordered. Chair moves that Senate Bill 816 do not pass, but that the committee substitute for Senate Bill 816 be adopted in lieu thereof and be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and 0 nays. Committee substitute for Senate Bill 816 will be reported to the full Senate with a favorable recommendation. Senator King recommends the committee substitute for Senate Bill 816 be recommended for local non-contested calendar. Any objection? Hearing none. So ordered. Chair moves that Senate Bill 1666 do not pass, but that the committee substitute for Senate Bill 1666 be adopted in lieu thereof, be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and 0 nays. The committee substitute for Senate Bill 1666 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends the committee substitute for Senate Bill 1666 be re-recommended for the local non-contested calendar. Is there any objection? Hearing none. So ordered. Chair moves that Senate Bill 1886 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and 0 nays. Senate Bill 1886 will be reported to the full Senate with a favorable recommendation. Senator Hagenbu recommends Senate Bill 1886 be recommended for the local non-contested calendar. Any objection? Hearing none. So ordered. Chair moves that Senate Bill 1980 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes, 0 nays. Senate Bill 1980 will be reported to the full Senate with a favorable recommendation. Senator King recommends Senate Bill 1980 be recommended for the local non-contested calendar. Is any objection? Hearing none. So ordered. Clerk knows that Vice Chairman Parker is present. Chair moves that Senate Bill 2580 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes and 0 nays. Senate Bill 2580 will be reported to the full Senate with a favorable recommendation. Senator Parker recommends Senate Bill 2580 be recommended for local non-contested. Any objection? Hearing none. So ordered. Chair moves that Senate Bill 2693 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes and 0 nays. Senate Bill 2693 will be reported to the full Senate with a favorable recommendation. Senator King recommends Senate Bill 2693 be recommended for the local and uncontested calendar. Is there objection? Hearing none. So ordered.
Yes, we did.
Adam? Chair moves that Senate Bill 2776 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 6 ayes.
There
no
be
nays.
6 ayes, 0 nays. Senate Bill 2776 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa recommends Senate Bill 2776 be recommended for local and uncontested calendar. Is there objection? Hearing none, so ordered. Chair moves that Senate Bill 1234 be reported to the full Senate with a recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa, Senator Huffman, Senator Miles, Senator King, Senator Hagenbu. 6 ayes, no nays.
There be 6 ayes, 0 nays. Senate Bill 1234 will be reported to the full Senate with a favorable recommendation. Senator King recommends Senate Bill 1234 be recommended for the local and uncontested calendar. Is there objection? Hearing none, so ordered.
I already told him.
Well, members, thank you all for being here. I know it's been a busy morning. This concludes our business for today, and the committee stands at recess subject to the call of the chair.